not only for this case, but for other cases as well in the future to come. There are pending applications that ICASA must entertain, which are waiting the outcome of this case.
And this court's judgment would give direction on how ICASA will deal with other matters?
Yes, correct.
So you are, in effect, approaching the court for advice and for direction. Is that the court's role?
Well, that is not the only basis on which we rely for our submission that it is in the interest of justice for the court to exercise its jurisdiction on this issue. We have dealt with them in paragraph 216 of our heads of argument. And I think the one that you have raised, I think, is just one of them. So from what you are raising, it may not be the best of the points, but there are other points that we have raised. Good morning, Justices. I appear on behalf of the applicant together with my learned junior, Ms. Lefaladi.
Thank you, Mr. Tsatsa.
May it please the Court, Justice Mkhandla and the Justice of the Constitutional Court, Mr. Ngcukaitobi, for the respondent, and I'm assisted by my learned friends, Mr. Zungu, as well as Mr. Sikhachi.
The first issue that we deal with is obviously the jurisdiction of this court to entertain the matter. We submit that the application raises constitutional issues. The application obviously started as a Paja review in which Open Heaven sought to vindicate its right to just administrative action as protected in Section 33 of the Constitution. It also raises the issue of the exercise of public power by ICASA. And the main issue here being that we submit that ICASA, as an organ of the state, is bound by the rule of law. It can only perform the functions and can only exercise the powers which are vested upon it by the law. And if it purports to exercise powers which are not vested upon it by law, then it infringes the rule of law. The powers of ICASA are set out in Section 4 of the ICASA Act, and a simple reading of that section reveals that there is, in fact, no power to condone non-compliance with statutory provision, particularly Section 19(2) of the Electronic Communications Act. Then the Electronic Communications Act itself deals with what is defined in it as individual licenses, and these are ordinarily your commercial broadcasting licenses. And it also then deals with class broadcasting licenses. And those are the licenses that we're dealing with in this application. The ECA deals with the granting of the licenses in Section 5, and then it deals with the renewal of the two licenses in Section 11 and Section 19 of the Electronic Communications Act. Section 11(9) of the ECA, which deals with the renewal of individual licenses, expressly empowers ICASA to condone the late filing of a renewal application. But that relates only to individual licenses. Class licenses with which we are dealing in this application are dealt with in Section 19 of the ECA. And Section 19(2) prescribes the time within which a renewal notice must be delivered to ICASA. It must be delivered 6 months, not later than 6 months before the expiry of the license. But what it doesn't do is to contain a provision such as the one contained in Section 11.9 of the same legislation, because it says absolutely nothing about the condonation of the late delivery of a renewal notice. There is clearly a distinction which the legislature has made in Section 11.9 of the ECA, because in Section 11.9 of the ECA, it expressly empowered to condone the late filing of the notice and to do so on good cause. But in Section 19.2, it didn't bring the same provision as far as class licenses are concerned. And that legislative choice, that distinction, is not contested in this application. It was never contested in the High Court. It was not contested in the SCA.
Just to start off, I know that you are not here representing the Parliament, but I just want to have an understanding. Maybe you can help us as a regulator, why there was an express provision under the individual licenses for condonation, and there is nothing when it comes to the class licenses. Perhaps if you could maybe provide, just tell us more about these two types of licenses.
Yes.
The distinction, if there's any distinction between them.
Yes. The individual licenses are your normal commercial broadcasting licenses, and the class licenses are your community radio stations. I don't exactly know the real reason, but from my experience, it does appear that the legislature must have been concerned about the manner in which community radio stations are regulated. And this is a classical example, Open Heaven is a classical example of it. If you'll see in the papers that from the time that the license had been granted, the people that were originally controlling the license and the radio station were somehow divested from it. Open Heaven itself says the radio station was captured from Hammanskraal, and it was operating from somewhere in Pretoria West. And those are the governance issues that we will submit may have influenced the legislature not to make those provisions.
For the commercial licenses, or I suppose that would be companies, they are then allowed, if one is late, they can apply for condonation.
Correct, yeah. So if a commercial radio station is late with its application for renewal, it is permitted in terms of Section 11.9 to apply for condonation for the submission of a renewal license, yes.
And community licenses, that provision is not there. But the provision that is there, for whose benefit is it? The 19, is it 19.2?
19.2, yes.
Yes.
Yes, that is we submit that is in the public interest for a variety of reasons. Because if a community radio station, for example, but the same applies to commercial radio stations as well, because what they get granted when they get two licenses. They get what is called a spectrum license. That is now a license to allow them to operate in the airwaves, and then a normal broadcasting license. For example, if you don't tell ICASA that you want to continue providing the service, ICASA may decide to allocate that particular spectrum to somewhere else, or it may advise the minister that this radio station and that radio station have not given me notice that they want to continue. You may need to issue an invitation to the public to apply for that particular spectrum. That may be the reason, yes.
Is that,
Yes.
is it possibly another reason would it not also to also assist ICASA to regularize its affairs as and when applications come in?
Yes. For example, if let's say a commercial radio station does not apply, the same reason that I've given would apply, and the reason that you have given would apply, because it usually for commercial, for class licenses, there's usually an invitation to apply for the license. And you may find that there's 20 or 40 applications that are granted at the same time. And by the time that these licenses expire, they may be expiring at the same time, and ICASA may need to be given sufficient time to know who is still in the running and who is not in the running for it to know how to manage the spectrum. But not in this context, because here an application is either in at 10 o'clock or it isn't. And if it is not, then that is the end of the game. That, I think, we have dealt with it in our heads of argument.
Will your argument be different if ICASA, if Open Heaven was within time to file the application, a renewal, through no fault of their own, on the examples that have been postulated, something happens at your offices and at ICASA's offices, and they can't accept the application. So would then, in those circumstances, you say to them, end of the story, cut-off period, shut down?
Well, that is where, I mean, if it was as a result of something at ICASA's office,
yes,
then the position will be different.
Why? And where would the question would be, now you say there has to be, ICASA must source the power elsewhere. And where is the power going to be sourced by ICASA to condone its own actions?
Oh yes, so I thought you were still on the substantial compliance issue.
I'm done there.
Ah, okay, yes. So if something were to happen at ICASA, but the application had been submitted.
No, they are going to ICASA to submit the application.
Yes.
Lo and behold, the example that has been put is that there is fire at ICASA.
Yes.
They are at the gate, there's nothing, and the security guy or security personnel cannot accept the application. What happens in those circumstances?
Well, something like that happened. It's said in the papers where there was a fire at ICASA, and at some point ICASA didn't know who had submitted and who had not submitted because of the fire. And then ICASA issued a notice to say everybody who had not yet submitted an application, a renewal notice, must now do so within a period of 30 days. That is what ICASA did at the time. Whether that was right or wrong.
But doing that,
yes.
What is that conduct in terms of the provision of Section 19.2?
Well, I can tell you that ICASA thought it was doing right at the time, but it did not have a power to do that.
So in your argument today,
yes,
what ICASA ought to have done was to say, we had a problem. It's none of your business. You were here on time. You could not shut down. Just think about it.
Yes.
And people would walk away and shut down the committee stations.
Well, it will not mean that they will not have had remedies.
Yeah, but we are debating the Section 19.2.
Yes.
Where you said it allows no opportunity at all. Once you don't come within the four corners, there is no implied power, there is no condonation, there is no discretion. It's
yes.
Open and shut.
Yes. So in that kind of a context, there will be nothing preventing ICASA, for example, to approach a court to say, I had a fire in my building. People could not submit their applications. and their applications were submitted and were rejected because they were submitted late, ICASA could have approached the court.
Thank you, Mr. Tsatsatwane. I'm just concerned about the question that the acting Deputy Chief Justice asked you and your response to it, which relates to the purpose of the statute and why it would be that individual license holders should be afforded the right to apply for condonation and why the other could not be implied in respect of communal license holders. I mean, essentially, in response to Justice Matopo's questions, you're suggesting that where condonation is sought by a community radio station, they would have to really approach the court for that condonation, whereas individual license holders, such as the big players, don't have to do so, because that's what the Act says. Now, can the Act really not be read to imply such a power in Section 19 to communal license holders?
No, we submit not, because if you're going to exercise your reading in power, you first have to find that the section is unconstitutional. Then you can read in some words into it.
Well, what about judgments such as Baxter in the Western Cape High Court, which was supported in Park Avenue by the SCA? What about those judgments which say you can read into a statute?
Yes, but in this case, the High Court was not asked to do it. The SCA was not asked to do it, and this court
it's not a formal reading, and that you can imply it from the terms of the statute. That's what Baxter said.
Yes.
You can imply that the power to condone exists when you grant an organ of state or somebody else, a body such as ICASA, a power to grant a license. You can imply then a power to condone where there, for instance, was a fire at the gate.
Yes, but in the context of this case, you have a clear indication from the statute itself that the legislature deliberately decided to treat the two licenses differently.
But what would the purpose for that be? I mean, that's what I don't understand.
Yes.
Why would you place such an onerous burden on community radio stations? What would the purpose of the statute be in doing so?
Well, the difficulty with that is I can only give you a guess, but and that is because that was not an issue which we had to address. And I think the best person to answer that question is probably the minister responsible for that legislation. But we can only speculate that it is pretty much because of the governance of the two types of radio stations.
But because that argument is so weak, with respect,
yes,
it suggests that you could imply the power.
Well, we submit that on the authority of the Amabungane case in this court, only if the purpose of the legislation as a whole is going to be negatively affected without that power being implied. But this is not such a case here. This is a case where you have got few community radio stations who do not comply with the time frame prescribed in Section 19.2.
Mr. Tsatswane,
Yes.
even if this matter does engage this court's jurisdiction, is it in the interests of justice that leave to appeal should be granted?
Yes.
Let me put it differently. What would be the practical effect between the parties of an order in this matter in favor of the applicant?
Well, we have outlined a long list of bases on which we submit it will be in the interest of justice. For example, from paragraph 2.16 of our heads of argument, I think all the debate that we are having now it does indicate that there is a need for this court to express its view on these issues. The matter is not only limited to open heaven. It applies to other community radio stations as well who have applied late, and our applications.
For now,
append.
can you please just confine yourself to my question, please?
Yes. Yes, in the context of between ICASA and Open Heaven, then there may not be any effect of it. Because on their version, even if the extension has retrospective, even if there is a retrospective effect, then that time will have passed.
You concede there might not be any effect on the parties per se.
Correct.
So is ICASA then just coming to this court for direction and for advice?
No. We're not coming here just for advice. The matter does raise a matter of public importance, and we say that in our heads of argument, not only for this case, but for other cases as well in the future to come. There are pending applications that ICASA must entertain, which are waiting the outcome of this case.
And this court's judgment would give direction on how ICASA will deal with other matters.
Yes, correct.
So you are, in effect, approaching the court for advice and for direction. Is that the court's role?
Well, that is not the only basis on which we rely for our submission that it is in the interest of justice for the court to exercise its jurisdiction on this issue. We have dealt with them from paragraph 216 of our heads of argument. And I think the one that you have raised, I think, is just one of them. So from what you are raising, it may not be the best of the points, but there are other points that we have raised.
Mr. Tshwane, I've got one question for you, and it relates to the debate that you had previously with Justice Ngcukaitobi. And the issue relates to the overarching interest of the public or the interest of justice, that
Yes.
this court must give attention to this matter. It appears from the arguments and the answers that you've given so far, the key battleground is the interaction between the principle of legality, that is ICASA's lack of express power, and the doctrine of implied ancillary powers under Ampugani.
Yes.
And if I've heard your answers to the questions that was raised with you, it appears that you want this court to follow the Ampugani approach, the strict approach of necessity. Now, the question here is, with regard to that strict literal approach, does that not frustrate ICASA's primary constitutional mandate to regulate broadcasting in the public interest?
We submit not, because you can imagine in a situation like this, and I think one of the Spectrum cases did come before this court, where there are other players in the industry who do not have access to Spectrum. It is not in the public interest if there may be Spectrum available somewhere because someone is no longer going to use it, that ICASA must know that that Spectrum is no longer going to be used and I can allocate it to other players that may be available. That is in the public interest. So the strict reading and following of Amabungane we submit will not frustrate that. In fact, it will enable ICASA to regulate better in the public interest when there's clarity on it.
But ICASA's primary constitutional mandate is to ensure that the broadcasting is regulated within the public interest.
Correct.
Now, Open Haven, are they not broadcasting within the public interest?
No, well, to the extent that they have a license, yes, they're broadcasting in the public interest. But again, they must do that within the prescribed regulatory framework. And the prescribed regulatory framework says 6 months before expiry of your license, you must give notice that you still want the spectrum.
Thank you.
Thank you, Mr. Tatawane. We'll take, we're done now with the questions.
That's it, please.
Thank you. We'll take a tea adjournment. Yes, Mr. Ngcukaitobi.
Yes, thank you. Thank you, Justice Ngcukaitobi. We think this case is far more simple, but ICASA is trying to complicate it, and there's really no need for that. I've benefited from the debate between the court and Mr. Tatawane, and it has facilitated my task for today. We think you'll benefit from our submissions if we address the following topics. First, we want to deal with the retrospectivity issue. We say the amended regulations are retrospective in their effect. They say they are not. Secondly, we want to deal with their condonation powers under Section 19.2 of the ECA, although somewhat that debate may be irrelevant depending on your findings on the first issue, namely the retrospective effect of the amended regulations. Thirdly, we're going to deal with an omnibus topics in which we deal with all the other technical arguments they've raised, such as the order granted was not the order you sought before the High Court, and the SCA was therefore wrong to dismiss their appeal. And then we'll conclude by considering issues of course. Against retrospective application of retrospective effect of legislation, therefore it only applies to those who will get their licenses after that date of the amendment. Of course, that contention is plainly untenable. This court has recognized, Justice Ngcukaitobi, in a number of judgments that we have a general presumption against the retrospective effect of legislation, but it is only a general presumption. It is rebuttable. It's a rebuttable presumption, and in appropriate circumstances, it will be rebutted by the language, the text of the regulation or the law itself, and in other circumstances, it will be rebutted by necessary implication. I think the SCA has said that in a number of judgments, and I think this court has also said it in S versus Mhlungu, a criminal case many years ago. So and of course, thirdly, the presumption will be rebutted where the amended regulation confers a benefit on those who are subject to it. Because remember, I think it was Justice Theron who debated the point with Mr. Tatawane. The presumption against retrospectivity is not there for its own sake. From many years ago, all of these judgments point the same thing. The whole idea behind the presumption is fairness. You don't want to interfere with people's rights that were acquired under previous legislation. But where there's no interference, there's only a benefit. Why not? It happens all the time when legislation, when laws are amended to confer benefits, especially in criminal cases. So clearly, this applies to all licenses, and you can determine that by the plain language of the regulation itself. How does it apply? They made the new period by specific reference to the effective date in circumstances where they knew that it would refer to a whole range of licensees who got their licenses many years ago, and they even in their regulations they define the effective date by maybe past, it may be present, it may be future. So they must have known. I mean, they regulate these licensees, and they definitely knew that it would apply to all of them. So at the SCA, ICASA was also invited to point to any interference against vested rights which the amended regulations would effect. they declined that invitation. They were not able to point to any. And the truth is, it is simply a fortuitous benefit on all the class licensees. It's just unfathomable why ICASA is fighting them tooth and nail for a benefit it objectively conferred on them. It intended to do that, and those are the consequences of those amended regulations. So we submit there clearly is there's no debate. I mean, ICASA has not attempted to address this point at all. I mean, mountains and mountains of arguments and long written submissions, but only 4 pages, about 4 or 5 pages, are devoted to this point. So it tells you that there's no answer to that issue. So we say, just Matopo, there's case law. Case law to the effect that where you apply amended laws prospectively, if the effect is to discriminate between two individuals, such legislation will necessarily be applied retrospectively. And one of those judgments we've cited in our heads of argument is an old judgment, Leck versus Estate Agents Affairs Board. I think we relied on page 611 of that judgment. The principle is simply that an inference of retrospectivity will be drawn where the prospective operation of regulations or new laws leads to absurdities. What are the absurdities here? We've tried to dramatize them in our heads of argument. We said, look at two licensees. You have myself, maybe Mr. Zungu. I got my license before the date of the amendment, maybe let's say 24 March 2021. What does that mean? My license, its validity is 5 years. But if Mr. Zungu gets his license a day later, 25 or 26, his license is valid for a period of 7 years. I mean, that's clearly absurd. By a difference of just a day between us acquiring or renewing our licenses, we get these stark results. And ICASA has not been able to explain these kind of absurdities. I mean, there's simply no logical reason why any lawgiver would enact such absurd results. So I mean, the argument is plainly inescapable. These regulations confer benefit. In this court recognized it in S versus Mhlungu that the presumption against retrospectivity is not meant to, to block benefits objectively conferred on subjects by new legislation. Where there's a benefit, regulations will or amended laws will apply retrospectively. So it's our submission that there's clearly no argument on this point. So if we succeed on this, I think we should be home on this on these proceedings. We should succeed in these applications, in this application for leave to appeal, because it will mean that Open Haven did not have to submit that renewal notice, which has led to all of these proceedings, because its license was valid up until September 2024, not 2022. So that whole debate becomes academic and largely irrelevant. And then can I then move on to the second point? And I'll be brief on it. So ICASA, we know from these records that ICASA has always condoned licensees for late filing of their notices. And what is interesting is this: the section upon which they rely for their new argument, for a belated argument today, has never been amended. So before 2021, going back to 2005, when the ECA was first enacted, they've been exercising that discretion on good cause shown, and they even enacted that discretion and power into regulations, until they later deleted that provision when the amendments were made in 2021. So obviously there are no express powers in Section 19.2, but this court has recognized in a number of judgments, and we refer to a few in our heads of argument. In some cases, implied powers will be necessary in order to enable an organ of state like ICASA to exercise those powers expressly conferred upon them. And we've again tried to dramatize the point, and it's not only fictional in this case, because they've admitted during their argument that one of the issues we referred to in our heads of argument, namely the fire, did actually happen in 2014. There was a time, I think there was still somewhere around Sentin, an incident which a fire ripped through their buildings, and then licensees, when they went to submit their renewal applications, could not do it because not because they were late, but because of ICASA's problems. It's not hard to imagine other circumstances, just like that. I mean, we just had COVID not long ago. I mean, 2 or 3 years ago, we just had COVID, in today's world, there are wars. I mean, there could be a war. Another country was just invaded, head of state seized and kidnapped not long ago by a superpower. So those instances are always objectively possible. And when ICASA approaches its powers in this rigid fashion, what are the consequences for that? I mean, they're going to be dramatic for innocent licensees who may not be to blame in those cases. I mean, just not long ago, ICASA's employees were on strike of some labor dispute, and it is not hard to imagine that a licensee like Open Heaven could be affected by events like that. You go there on your last day to submit your renewal notice, and employees are busy striking, and as a result, you can't do that. It looks like what ICASA is going to say is, well, it's your problem. Go on and let your license expire. And most importantly, we want to emphasize this, Justice Ngcukaitobi. The period, the 6 months period, it's admitted on these papers that that is largely for ICASA's benefit, and we agree on two things with ICASA. First, we say that purpose allows them, that 6 months period allows them to avoid a last-minute rush. Licensees all at the door trying to submit their renewal notices. So it gives them enough time to process those renewal notices. Secondly, it gives them time to manage the spectrum. With these radio stations, ICASA has a spectrum plan where it allocates spectrum bands to different radio stations. So it also allows them enough time to deal with that spectrum allocation. So, I mean, given this, the 14 months out of that period, but the license itself has not yet expired. It would only expire in about 5 or 6 months' time. ICASA says, well, there's nothing I can do about it. Could those objectives not be those objectives for which that period, 6 months period, serves, not be fulfilled within that period? Of course, it would be fulfilled. So ICASA is clearly unreasonable. We've looked at some of the cases decided by this court on implied powers. Like if I still recall, Masetla for an example, I think the president had had an express power to appoint the head of intelligence, but there was no express provision on whether or not he had the power to fire the president. And this court, quite correctly, in our view, said that that power to dismiss is a necessary corollary of the power to appoint. It's very evident in this case that if ICASA, approaches its powers the way it does, we're going to be in a cul-de-sac very soon. The licensees are not to blame, yet they are losing their licenses through no fault of their own. We respectfully submit that that should not be accepted. We know from this record that while the appeal at the SCA was pending, Openhaven submitted a conditional renewal notice based on the 7 months period, and ICASA's reaction was an iron hand of bureaucracy. I just want to get this. An iron hand of bureaucracy. A reasonable proposal is made to them. Say, well, the appeal's pending. We think we may win on this retrospectivity point. And when we win, we don't want to be confronted with a situation where we've won the main argument, but we no longer have a license because we failed to renew it timeously, 6 months before the period expires. We therefore submit this application conditionally, depending on the outcome of those proceedings. Alternatively, if you don't want to accept it, please give us an undertaking that you will not regard our license as having expired for our failure to submit a renewal license. Their response is really dramatic. Another instance of bureaucratic oppression. They said, no, we're not going to do that. And in their tough language, volume 6, page 49, those lawyers writing on behalf of ICASA, the above, I'll read from the second sentence. Any unlawful conduct by your client will be met with the appropriate law enforcement measures, and your client is called upon to resist the temptation to broadcast without a license as suggested in your letter. It's really dramatic, especially for ICASA. Remember, ICASA is not only an organ of state; it is a Chapter 9 institution, and one of its purposes is to regulate broadcasting in the public interest. And some of those objectives are now filtered through to the ECA. It must encourage and support community broadcasting, support SMEs, ensure a diversity of views and opinions in our public broadcasting. So it looks like their approach effectively is to, as a consequence of this interpretation, will lead to a new aristocracy in broadcasting, in which poor communities are excluded from broadcasting. They can't speak their own languages. They can't practice their culture, listen to news in their own home languages. We think that is wrong, and this court should not tolerate that.
Mr. Ngcukaitobi, all right, thank you, Mr. Ngcukaitobi. Yes. I just needed to get some clarification about why you submit that ICASA's rights are not infringed by the first interpretation that they propose. My understanding of ICASA's argument is that they would like to retain for themselves the right to assess whether or not your client has complied with its license conditions. And an automatic extension to 7 years deprives them of that right. And so it's not as if this is a benefit conferring provision without an invasion of existing rights. How should we address that concern?
No, well, Justice Ngcukaitobi, I think they're incorrect. There's no right there. It is a power, not a right. I mean, a right is obviously is always in the nature of some entitlement. Like you get a license, you can do that. You can run a business, run a fiber company, or that sort of thing. But what they are contending.
No, I understand.
Yes.
But
Yes.
Are they actually prohibited from investigating your client's compliance by the mere extension of 5 years?
No, they're not. They're not. Because remember, all of these broadcasters are still subject to their regulation. They're not prevented from investigating them. And if they find any issues of non-compliance, enforce the regulations, or even cancel or suspend the
And where would they get that power from?
I think that power, I think it should be within the ECA, because I can look for those provisions. Remember these licenses, once granted.
No, I understand. There's
Yes.
quite a lot of externalities to be explained.
Yes.
If you could just assist me with identifying the answer that look, ICASA is wrong.
Yes.
They are not prohibited. This is their power to investigate if we have not complied.
I'm sorry. Can I get the question again?
Just assist me with a
Yes.
direct answer by identifying where the power is to answer ICASA's concern that an automatic extension deprives them the right to say it's not the right, it's the power, but let's forget about the technical
Yes.
label.
Yes.
But where would the power be to investigate your client's compliance in order to enable ICASA to terminate the license? Because that's the argument they make, that, well, you've now got an extra 2 years. We can't do anything about you for the next 2 years.
But clearly that's incorrect.
Yes, just give me the section that would be applicable.
I don't think there would be a direct section, but we've attached in our heads of arguments the regulations dealing with these class broadcasters, and they deal with a range of things. For example, you must always have a board. Your programming must be compliant with your license conditions. You must submit compliance reports as and when required under those regulations. So even if you get that extension, that 2-year extension, you still must comply with those regulations and maybe other regulations that may be applicable to you.
No, I understand that. I just want to get the actual answer to say,
Yeah.
look, they are wrong. This is their power. They can discipline us. They can take our license.
Yes.
Now, the reason is because I couldn't find that in the Electronic Communications Act,
Yes.
because the power there to terminate seems to exist only in respect of individual licenses.
Yeah.
And I couldn't find a comparable provision in respect of class licenses. Could you find it? Or can you just?
No.
All right. Then, that then meant that I had to look elsewhere.
Yes.
And in the ICASA Act, I just want your submissions whether this would be applicable.
Yes.
Under Section 17, capital A,
Yes.
which deals with the Complaints Committee,
Right.
which seems to be overarching and deals with every complaint regardless of the
Yes.
classification.
Yes.
Would that be applicable?
Yeah, I think ICASA does that every day. I mean, whenever there are issues of non-compliance by these radio stations, they refer them to the CCC for prosecution. And the CCC, after hearing argument and finding a substantial non-compliance, may impose fines and maybe in some cases propose the cancellation of a license itself.
Yes. But would that be the section that gives them the power to discipline your client if your client doesn't comply?
Yes, I think so, yes.
Yes. So would that be then the reason why their main submission is wrong, that the extension deprives them the power to discipline your client?
I mean, that must be plainly wrong. I mean, there's the relationship between regulators and licensees is always through licensing. I mean, they still remain under ICASA's regulatory powers, and where there's non-compliance, they may be prosecuted and face the risk of losing a license or exorbitant fines.
Thank you, 8th Street.
Yes.
Now, if we put aside the authority in Pepper Bay and in JS Moroka,
Yes.
in Gous, the Supreme Court of Appeal said that there's a general rule,
Yes.
or the general rule is that statutory bodies only have powers that are expressly conferred by law. And this court has held that ancillary powers will only be implied where they are reasonably necessary for the exercise of a primary power.
Yes.
Now, this is my question to you, Mr. Ngcukaitobi.
Yes.
Which of ICASA's primary powers will it be unable to exercise without the ancillary power to condone non-compliance?
Yes. So let me just begin with Amapungane. As I recall, the principle there was that ancillary powers will be necessary where the primary powers, whether express or implied, won't be, you won't be able to exercise them. So the primary power ICASA has in terms of 19.2 is to decide on those renewal notices. Once received, decide on a renewal notice or renewal application. So on the instances we've dramatized before this court, we're going to run into a cul-de-sac very soon. There's a strike, there's a fire in their building. They're not going to be able to exercise those powers, and the licensee is not going to be at fault. What are we going to do there? So Mr. Tsatsawane, as I listened to him, said, well, we might in that case need to go to the High Court in order to get some relief in terms of which we ask them to allow us to exercise some powers. But when you come to the court, you're going to say, where are the powers on their own argument? You're going to say, as a judge, I must give you powers to do this renewal, but where am I gonna get them? So I think that's so we need to be cautious cautious on against that argument. So in simple words, Justice Theron, their primary power is to decide on those renewal applications, and there will be clearly on the submissions we've made instances where they will not be able to exercise those powers.
Can you give an example? You say there will be instances. Can you give an example of such an instance?
It happened here. In 2014, ICASA there was a fire in their building, and when certain licensees wanted to go and submit their renewal notices, they couldn't do that because there are work people and emergency staff and things like that. And yes.
My question, Mr. Ngcukaitobi, is
yes.
Which primary powers
Yes.
will ICASA be unable to exercise if the ancillary power to condone is not granted?
Yes. The primary power is to decide a renewal application, Justice Theron, because only they have the power to decide that those renewal notices under section 19.2. That is their primary power. But I mean, when you read through that section, you won't get it in such express language. ICASA has the power to decide on this, but it's clearly implicit there, and I think it's consistent with what this court said in Amapungane, that those primary powers may be express or implied, but in certain instances they will need implied ancillary powers in order for an organ of state to be able to exercise them.
I have some difficulty with the statement that express powers can be implied.
Okay. Well, but so it's your judgment. I'm not sure if you're part of the panel there in Amapungane. we're giving you back your words in Amapungane. So that's...
I'm on the same page, Mr. Ngcukaitobi,
I'm
but
sorry.
I will leave it there.
I apologize.
I want to deal with the argument as to whether, and this is the applicant's argument,
Yes.
there has been a conflation of the test for an implied power to condone and the test for material compliance with legislation. And I want you to consider, what are we dealing with in this case? Now, the test in SA Eagle deals with the waiver of a requirement.
Yes.
And it holds that a benefit enacted for a particular body may be waived, provided no public interest is affected.
Yes.
So that deals with the power to condone. The test for material compliance asks whether the purpose for which the requirement has been enacted has been fulfilled.
Yes.
So what are we dealing with and what's the test?
Just Thoron, I think we're dealing with both of those. We've raised them in our submissions. And first, we say on this condonation point, there are implied powers, and we rely on these court's judgments, including Amapungane. And then we say, if you're not with us on that, then ICASA should have condoned that late filing because it was in the public interest to do so. And thirdly, and maybe somewhat clumsily, I don't think we've raised it squarely, is that there was substantial compliance given the purpose of that section.
Now, doesn't your answer in fact demonstrate
Yeah.
why this court should deal with the matter? Because let me rephrase.
Yes.
I want you to consider what the effect of this judgment on the implied powers of all administrators across the country would be
Yes.
if this court finds that the SCA judgment stands. Would it not create uncertainty as to which requirements an administrator can waive or condone and when it is entitled to do so?
I think there's enough case law in our jurisprudence, and as I understand the approach, it is all flexibility. I mean, there's no tick box exercise in which administrators advise to ignore this, take into account that and that sort of thing. I think it's that flexibility, and you know, in most cases, there's the whole notion of a good cause shown. It happens in a lot of other areas of law, but we think it should all be around flexibility and context, taking into account the effects of each individual case.
My last question, Mr. Ngcukaitobi.
Thank you.
How does the present case differ from Liberal Party, where the applicants were just 21 minutes late?
Yes.
How does it differ from Pepper Bay, where the applicants were a day late?
Yes.
And in those cases, the court found there was no power to condone.
Yes.
And the court didn't venture into the material compliance analysis.
Yes.
So which cases are right? Which cases are wrong? What should we do?
I think the material difference, Justice Theron, first, on the very same paragraph relied upon by Mr. Tsatsawan, seems to undermine his very argument. They say there, I think effectively, the Electoral Commission has no power to condone the late filing in this case. And then this court continues in the next sentence. It says, especially in circumstances where there is no objective evidence on the record that they have done a similar thing in the past. But it's wholly different here. The case is altogether different. There's a mountain of evidence. I'm being dramatic. It's not a mountain of evidence. There are instances in which ICASA has done exactly the same thing, exercised the very same powers. And we pointed to those instances in our heads of argument, that general notice of 2014, and they also had those 2008 regulations in which they made that provision for condonation in instances of late filing.
Here.
Thank you.
Sorry, Mr. Nguta, to
Yes.
take you back.
Yes,
But on the debate you've just had with Justice Teron,
yes.
I think the question is by how much do you want to win? By 2-0 or by 1-0? You see, because how does this affect your client, whether or not ICASA has the power to condone? Because it seems not to affect your client at all.
No, I embrace your.
So then, why then are you resisting it? Your client is only affected by the retrospectivity issue.
Yes.
So if we decide that in your client's favor, so what's your bone then?
Yeah, I mean, I just want to cover all bases.
Yes, no, but what's the relevance to your client? I think,
Yes.
I would imagine that the short answer is
Yes.
that this is irrelevant to my client.
No, it is,
If my
it is.
client is right on the retrospectivity issue,
Yes.
the court must do whatever it wants to do in relation to the condonation issue.
I
It's
accept
only ICASA that's interested in that fight.
I accept
Your
that.
client is on time in relation to its extension after the 2 years.
Correct.
Thank you.
I accept that.